Ladies and gentlemen, dear speakers, good morning. It's my pleasure and honor to chair this session on legal questions regarding Cyprus in the Commonwealth after two sessions this morning on the diplomatic history of Cyprus' accession to Commonwealth and the political perspective. In the framework of this session, our speakers will discuss specific legal questions on this relationship between Cyprus and the Commonwealth. I'm very pleased that all three speakers are young scholars and researchers in their respective fields. They are all three PhD candidates, and they do master their research objectives. Our first speaker is going to be Ms. Katerina Elia. Ms. Elia is a PhD candidate and also an adjunct faculty at the School of Law of the University of Nicosia. Her topic is going to be Cyprus contract law, assimilations of and deviations from common law. This is a very interesting topic indeed, regarding, especially regarding us as attorneys, as lawyers, and we are looking forward to hear her presentation. Katerina, I believe you don't have a PowerPoint presentation, isn't it right? So it's going to be by heart. Okay, I expect this presentation to last like 13 minutes, if that's okay with you. The floor is yours. Katerina, you're muted. You're muted. Please unmute yourself. Okay. It's story of our lives, huh? This mute and unmute story this year.
Thank you very much. Thank you, Dr. Plevri, for the brief introduction. My announcement endeavors to examine the incorporation or non-incorporation of common law in the Cypriot legal order, with special focus on contract law. The starting point of this discussion is the nature of the Cypriot legal system. Cyprus is not a purely common law country. It has been characterized by academics as a mixed or hybrid legal system, as it is built upon the dual foundations of common law and civil law. More specifically, common law dominates in the field of private law, with a major exception of family law, whereas civil law dominates in the field of public law. Although we do not endeavor to approach this topic from a historical perspective, it's worth mentioning the words of Simeonides, that the diverse elements that compose the law of Cyprus owe their origin and survival to its troubled political history. They are actually accidents of history. According to Article 188 of the Cypriot Constitution, the laws which were in force during the British rule of Cyprus remained in force after the independence, to the extent that they are not subsequently repealed or modified, and to the extent that they are not contrary to or inconsistent with the Constitution. Additionally, and further than the constitutional text, according to Article 29(1)(c) of the Court of Justice Law 1960, the law to be applied by every court in the exercise of its civil or criminal jurisdiction includes common law and the principles of equity, save insofar as they are not inconsistent with the Constitution, international treaty, or legislation, either enacted in accordance with the Constitution or remain in force in accordance with Article 188. This provision contains no temporal limitations. Rather, it authorizes the application of not only the pre-independence common law, but also the post-independence common law. It has been criticized as it means that a post-independent decision of the House of Lords or the UK Supreme Court would be binding on the Court of Cyprus, even if a subsequent statute of the British Parliament superseded that decision. To that end, the Supreme Court in Constantinou and Panagidis, 1984, in applying a common law cause of action that had been abolished by statute in England, stated that Section 29(1)(c) incorporates the common law, not English law, as applicable in England at any one time. Interestingly, in a subsequent case, Police versus Xidia, 1992, the Supreme Court stated that the essence of the Cypriot jurisprudence is that the Supreme Court of Cyprus is not bound by the English case law, but considers the decisions of English, Scottish, and Irish courts have persuasive force, and as a matter of judicial courtesy, the Cypriot courts shall follow the decisions of the English appeal courts unless they are convinced that the decisions are wrong. In the case of Kemtaxi versus Tryphonos, 1969, the Supreme Court noted that in Cyprus, the courts, in adapting the English common law to meet the changing needs of time, must also take into account local conditions. Subsequently, in the classic case Paikos versus Kondemeniotis, 1989, the Supreme Court clarified that the common law, not as modified by statute, is applicable in Cyprus if the following are satisfied. First, no other provision has been made by any law to the effect of excluding the application of common law. Second, the common law is not inconsistent with or contrary to the Constitution. And lastly, is suitable for Cyprus and to local conditions. Thus, compatibility with the Constitution and Cypriot legislation and suitability for Cyprus seem to be the two main conditions for the application of common law. Cypriot courts will therefore apply common law principles where there is no Cypriot legislation in force and insofar as existing Cypriot legislation is not contradicted. One of the most important pieces of legislation that remain in force since the British rule is the contract law Cap 149. Cap 149 is actually a codification of the common law principles on contract law and was modeled on the Indian Contract Act 1872. Interestingly, Section 2 of Cap 149 provides that the law shall be interpreted in accordance with the principles of legal interpretation obtaining in England, and expressions used in it shall be presumed as so far as consistent with their context, and except as may be otherwise expressly provided, to be used with the meaning attaching to them in English law and shall be construed in accordance therewith. As stated in the case of Papadopoulou and Polikarpou, 1968, not only the legislator expressly provided a general rule of construction for the contract law in Section 2.2, but the Supreme Court of Cyprus, in a line of cases, took the view that statutory provisions in local legislation intended to codify the English common law should be interpreted and construed in line with the common law which they purported to codify. It is also well established that Cap 149, similarly to the civil wrongs law, is not exhaustive, as it does not provide for all actionable acts nor for all damages caused thereby. It merely codifies the English common law on the subject as existed at the time of the codification. Although it is generally accepted that common law dominates in the field of contract law in Cyprus, it's worth examining the instances where the Cypriot jurisprudence is alleged to have deviated from the common law tradition. Such instances are mainly the law of past consideration and consumer law. For the purposes of this presentation, we will focus on past consideration. As to consumer law, we may note that the introduction of European law in the Cypriot legal order is gradually transforming the Cypriot common law tradition in this area. I proceed to past consideration. The rule in English law is that past consideration is no consideration. Consideration is the price for which the promise of the other is bought. Therefore, consideration for a promise has to be given in return for a promise. If a party makes a promise subsequent to some action carried out by the other party, then, as a general rule, that promise or consideration is past in relation to the promise. Therefore, that promise can only be regarded as an expression of gratitude and gift and nothing more. It does not form a legally valid contract. Of course, this general rule is subject to exceptions. One of such exceptions, as first established in the classic case Lamblade versus Braithwaite 1615, arises where the act was done at the promisor's request and both parties understood that the act was to be remunerated further by a payment or some other benefit. Under these conditions, an act done before the giving of a promise to make a payment can be legal consideration. With regards to Cypriot law, the starting point is section 22D of Cap 149. It provides that when, at the desire of the promissor, the promise or the promisee or any other person has done or abstained from doing something, such act or absistence or promise is called a consideration for the promise. It is clear from the legislation text that the Cypriot law was meant to be consonant with common law. Nevertheless, the jurisprudence of the Supreme Court seems to have considered otherwise. The Supreme Court in Raif versus Dervish, a case of 1971, stated obiter that past consideration may well be good consideration, sufficient to support a valid contract under Cypriot law. In Romanos and Chrysanthou, 1991, the Supreme Court, with reference to Section 2, stated that past consideration is good and legal. In that case, the respondent personally issued a check for the payment of his company's debt. The question was whether there was sufficient consideration for the check. The Supreme Court considered that there was legal consideration. Nevertheless, it did not make any reference to the requirement of good past consideration or the requirement of promissor's desire under Section 22D. It may be noted that under discussion in that case was the consideration for a check. According to the explicit provisions of Cap 262, which regulates checks, to which the Supreme Court made a reference, a past debt is sufficient consideration for a check. It seems that Cap 262 makes past consideration good consideration for checks. The Supreme Court seems to have conflated the two distinct situations, the provisions of contract law under Cap 149 and the specific provisions of Cap 262. Judge Nicolaou, in his dissenting judgment in the subsequent case, Vasilikou and Kathijoti, 1998, criticized that past consideration was not even an issue in Romanos in view of its particular facts. In Vasilikou and Kathijoti, the majority of the Supreme Court followed Romanos. The respondent alleged that his guarantee for his company's debts, given after having become payable, was not supported by consideration. In following the reasoning of Romanos, the Supreme Court decided that the guarantee concerned an existing debt that was created by previous transaction between the appellant and the respondent's company, and therefore there was legal consideration. Judge Nicolaou, in his dissenting opinion, upheld the decision of the first instance court in that the guarantee was a promise given in relation to a clearly past action, and it was not the result of a request from the respondent in order to be in good past consideration, according to Section 22D. Judge Nicolaou stated clearly that past consideration is good consideration only if the past action in relation to which a future promise is given by the other party is done as a result of the request of that second party. On the same lines, with the majority of the Supreme Court in Kathijoti, in Zervos and Trapeza Kipru 2013, the Supreme Court followed Raif, Dervish, Romanos, and Vasilikou in agreeing with the first instance court that, according to the Cypriot jurisprudence, past consideration is considered on the basis of Section 2 of Cap 149 legal and acceptable, by contrast to what is in force in England. And this is noted in the decision. In view of the above, we may conclude that the Cypriot jurisprudence indeed deviates from common law on the issue of past consideration. Although the text of Cap 149 codifies the common law position, the jurisprudence seems to have followed a different route from that legislatively intended. Surely, the jurisprudence needs to be reconsidered, not only because it seems to have negated the request requirement of Section 22D, of CAP 149, but also because the qualification of past consideration as good consideration, irrespective of the request requirement, seems to clash with a basic contract law principle that consideration for a promise has to be given in return for a promise. Otherwise, the causal link between the two promises that is required for the creation of an enforceable contract is hardly established. Even the request requirement, although generally approached as an exception to the general rule, may not be considered as an exception, but merely reflect the normal requirement of the needs for consideration. To sum up, despite the deviation that I described previously, it is common ground that in general and mostly Cypriot contract law is based on and follows common law, the effect of which is still dominant. Thank you very much.
Thank you, Katerina, for this very interesting presentation. It is indeed a very interesting phenomenon. This the hybrid mixed law system of Cyprus. We can understand, and I keep the fact that the contract law of Cyprus is closer to common law and to the principle of equity rather than continental law, of course. Thank you for this interesting case law. Case law is always an important tool for the interpretation of law. And of course, again, the dissenting opinions are always very important to discuss and to study. Of course, the harmonization of common law with the Cypriot law should also take under account the local conditions, as you said, in order to create a Cypriot lex contractus, a unique one, an identity. So thank you again. And we no further delay. The presentation of Ms. Carollann Braum will follow. Ms. Braum is a PhD candidate, Institute of Commonwealth Studies, University of London, and her very interesting topic indeed is the role of legal measures and remedies to address conflict in Cyprus from 1955 to present day, values, expectations, and achievements. Three very strong words, Ms. Braum: values, expectations, and achievements. You have 13 minutes. Thank you.
Thank you very much. I'm going to share my screen.
Yes.
Okay, let's see. All right, let's see.
May technology be in our side.
Exactly. Can you see my PowerPoint presentation?
Yes, we can. Thank you. You may proceed.
Perfect. Thank you. So yes, before I begin, the words I chose, values, expectations, and achievements, I think are very strong words. The reasons that I wanted to approach it this way was to look not so specifically at the legal measures themselves, not so in depth, though we will, but rather to look at what people expected from them. What, again, as it says, what values the different legal measures have in terms of resolving conflict, and then, of course, whether or not they achieved things. And we'll look at this from a few different standpoints. It will be from the international standpoint, of course, and we'll go through some of the General Assembly and the Security Council resolutions from the United Nations, and then also from the individual standpoint. And we'll conclude by really focusing in on one of the more recent cases in the UK dealing with the AUTH torture victims. So how these legal measures basically have played out over the years. So I've just chose a small sampling because I've got 13 minutes, so I cannot possibly talk about everything in a short period of time. But I tried to pick some that would be representative of these different perspectives. So we're going to look at the European Commission applications and reports, briefly on the Treaty of Guarantee, and then spend a bit of time on the resolutions from the United Nations. And I would like to spend approximately half of the time, hopefully, on the recent case, because as we are talking about the role of the Commonwealth, I thought it was particularly interesting to look at the case in the United Kingdom that was brought by the torture victims from Cyprus. All right, so to begin, I'm going to jump right in with the European Commission case that was brought in the midst of the emergency in Cyprus between 1955 and 1959. So as we can see, of course, this was brought by Greece on behalf of the Cypriot people, and it was against the United Kingdom. So at the beginning, the European Commission had to determine a question of admissibility. Of course, this is kind of a relatively new approach in terms of after World War II and kind of developing the case law in this area. So we see them having to evaluate whether or not they even have the jurisdiction, basically, or the ability to hear the case, which they did, but not before Greece limited its application to just looking at the legislative and the administrative practices that were ongoing in Cyprus. So they had to make it quite focused in that regard. Then there was the European Commission's report that came out a couple of years later. And so here, of course, first they had to analyze in depth whether they did, in fact, have the authority to pronounce judgment. When it was looking at the emergency legislation that was passed during the Cyprus emergency, of course, by the UK. In the end, they did establish that they had authority to decide the case, but the outcome was not, I suppose, what Greece or the Cypriot people were hoping for by any measure, because the Commission held that the emergency that was ongoing threatened the life of the nation. Of course, this nation being the UK and looking at Cyprus as a colony. So the use of emergency legislation and regulations, including curfews, detentions without trial, arrests without warrant, deportation, these types of measures that should fly quite directly in the face of human rights obligations, were legitimate, or they were legitimized by this decision, because they said that it was justified by the emergency that was ongoing on the island, and that Britain's attempts to kind of quell the violence and maintain order and the status quo that it had should continue, and that justified the strict regulations and even what could be deemed potentially otherwise as human rights violations. So before moving on to the Treaty of Guarantee, just kind of looking at this in context from the international standpoint, one can imagine the very early days of creating and evolving these rules and how to approach these types of conflicts. So the European Commission is definitely undergoing a diplomatic and international relations balancing act, while at the same time trying to make sure that how they are interpreting human rights rules and laws, treaties and standards should move forward the right way. And of course, being in 1958, this is the end of the colonial period, but it's not over yet. So I think that this was a really interesting decision when we look at it in the political context. And it's particularly interesting as we move forward through this discussion and we look at the role of upholding self-determination, especially after 1960, after the independence, how important that becomes. So we see quite a flip in a short period of years. Of course, the presentations before have done an excellent job giving a background of the Treaty of Guarantee and much more. So I don't need to say so much. So I'll focus in on Article 2 and how, of course, Greece, Turkey, and the United Kingdom undertook to prohibit, so far as concerns them, any activity aimed at promoting, directly or indirectly, either union of Cyprus with any other state or partition of the island. As you all know very well, this didn't quite play out as expected. And then this is coming from a discussion by Mr. Constantinou from 2017, as he was discussing the role of the Treaty of Guarantee in the negotiations at the time in 2017. And he was highlighting how much this has failed. It failed on the Greek side, it failed on the Turkish side in both the 1960s and then into the 1970s. And then I really appreciated the comment earlier on how during these situations, Britain was taking pictures. And so that kind of seems to sum up what was going on here. And so we see that failure of Great Britain as well going on. It was an interesting discussion here on how the Treaty of Guarantee could still play an important role in the negotiations, particularly by focusing on what he called soft guarantees that were actually written out in the treaty or implied within the treaty. And that this should be the legally binding obligation that potential disputes will be peacefully resolved, including through international adjudication. We will see that there's been many, many steps at negotiations and mediation, but then perhaps not quite as much looking at, for example, going to the International Court of Justice and looking at the adjudication there and legally binding adjudication. But that's something that seems to be a bit more of perhaps a hope or a possibility or just a discussion point at the very least. All right, so I'm not going to spend too much more time on that, but rather I want to go in and look first at the General Assembly resolutions and then at the Security Council resolutions. I'm not going to go so in depth into each of them, but rather I want to kind of focus on the general approach that was taken and also kind of the evolution of the approach from the 1950s in the case of the General Assembly and then the 1960s from the case of the Security Council. Of course, as we know, in 1954, whenever Greece, kind of on behalf of the Cypriot people and also at the instigation of their own citizens, kind of took up the case of the Greek Cypriots and first tried to have negotiations with the United Kingdom in terms of promoting and hopefully moving towards the self-determination of the people of Cyprus. And then in July of 1954, we get that, that famous statement from Colonial Secretary Henry Hopkinson of saying that the full right of self-determination for the Cypriot people would never be on the table. And that, of course, then really kind of sped things up. And we see Greece taking the case, so to speak, before the United Nations General Assembly. And there was some momentum and hope that this new organization, this new United Nations, would, with its strong charter and what appeared to be a great amount of hope in terms of its ability to resolve legal conflicts and uphold this new, Declaration of Human Rights and these other documents that were forthcoming. So this belief that they could go to that organization and really find action and find strong decisions. And as we know, is what they found instead was politics, diplomacy, international relations. And ultimately, the General Assembly decided in December of 1954 that it was inappropriate at the time to look at this question, of course, deferring to the United Kingdom and I would presumably diplomatic and international pressure there. Then, as we know, then that led to 1955. We see the beginning of stronger tactics and violence in order to move the call for self-determination forward. Then a couple of years later, the UN General Assembly is kind of getting a little more, we see more concern as the situation has intensified and they're expressing confidence that the parties can reach a peaceful, democratic, and just solution. So again, the General Assembly itself is not wading in, but rather we see them deferring to the UK and to the parties to resolve the conflict. And then over the next couple of years, in the different periods where we see conflict, we see the General Assembly calling on respect for sovereignty, the withdrawal of foreign troops, and then recommending the Security Council to adopt measures. So kind of deferring things, of course, to the Security Council, whose role is to maintain international peace and security. Not a lot of action. Not as much as the original hope that would have been in 1954 when they originally took the case to the General Assembly. We don't see as much concrete action, perhaps, as they originally hoped. With the Security Council, we don't see them getting involved. Of course, in 1960, whenever Cyprus is admitted to the UN, but then they start getting involved a bit more in 1964 and then into the 1970s as well. 1964, of course, establishing the peacekeeping forces. And then again, we can imagine a great deal of hope that the establishment of the peacekeeping forces is really going to solve a lot of the problems and make a lot of progress. The majority of the Security Council resolutions, which I do not have listed out here, are simply renewing the mandate of the peacekeepers up until very, very recently, of course. So again, this is one of those situations where we see that initial hope and promise, maybe falling prey to the realities of the world. We know at this point in time, it's in the middle of the Cold War. There's a lot of interests of other states that are in play here, including the United States, the USSR. And so perhaps the force and the expectation of what the Security Council could do might be watered down as well. Then, of course, the United Kingdom, being one of the permanent 5 members of the Security Council, would be able to veto, should they choose, any stronger language. So we see calling on parties to cease fire. We see reaffirming its previous statements, invalidating the Turkish Republic of Northern Cyprus, and so on and so forth. So they're taking a stand, and of course, Cyprus is one of the oldest conflicts that's ongoing before the Security Council. But yet, how they are able to resolve it, again, highlights problems and is not quite as effective as perhaps could be hoped for. Then we see this into starting with the 1990s and moving forward. Of course, this is after the Cold War, so we could expect a bit of a shift. And in fact, in some ways, we do see a shift, which is calling for more detailed negotiations. And then in the a bit later, we see the Annan plan coming into play as well and supporting that. But you can note that the majority of what's going on here is hoping for negotiations, facilitating negotiations, and then also noting any scale up of the military or any ongoing violence. So kind of documenting that. I know in terms of international relations and the United Nations action, Cyprus has been called the graveyard of diplomacy or diplomats because of the difficulties that they have faced. But you do see this ongoing effort by the Security Council to constantly fall back to negotiations. There have been calls for a fact-finding mission by the Security Council, for example, to help facilitate perhaps more productive negotiations. But this is still just something that is kind of an idea, perhaps, and not coming to fruition quite yet. So that's just a bit of a background to what's going on and how maybe these legal measures are approached at first, and then kind of how they end up playing out, often being drawn out and having less productive conclusions or achievements than one might hope. But that was at the more kind of the community-wide, the international scale. So now we're going to look a bit more focused on the recent case that was in 2018. And this is the Sophocleos and others versus the Secretary of State for the Foreign and Commonwealth Office and the Secretary of State for Defense. I appreciated the previous discussion on whether or not Cyprus should apply the English common law, because here now we have the a English case deciding whether or not to apply the laws of Cyprus. So kind of seeing it from the other side, which I thought was a nice balance. This, of course, was the torture case that was not brought under human rights law, but rather was brought under the law of torts before the English High Court. Of course, it came about following the 2012 release of all of the documents in the National Archives that did describe acts of torture and abuse. So this evidence became available at that point in time. Also following some of the other cases, the Mau Mau case, for example, in 2012, and the Kiu case from Malaya that we see in 2016. So we're seeing kind of a range of cases from colonial violence coming about following the release of the documents.
Carollann, I'm sorry, could you please conclude?
Yep, I can. So looking at of course, the torture that was assumed, the facts were assumed here. I think some of the most interesting parts of this case, aside from the torture that was alleged, was the fact that it was not based yet on the substance, but rather was on procedure. So they initially brought up the question of vicarious liability, and it's brought in negligence. Double actionability becomes a very important point. Is what we really see in this case, though, is that it's procedural. So they're going through and they're trying to determine which law applies here, because if the law of Cyprus applies, then the case is subject to statute of limitations. Whereas allowing the case to move forward in the UK, they would can overcome those limitations and the case would not be time barred. At the first instance, Justice Kerr says, it's fair for the UK to apply their law and be held to account. So that's what he decided. The Court of Appeals, however, came back and determined that they had to focus on which law applied, England or Cyprus. And they really focused in on the rule of double actionability and found that both of the laws were applicable here in this case. And so then it would need to go back to trial, of course. And there would be the other issues of vicarious liability, the statute of limitations, etc. However, the case was settled. So rather than going through the long, lengthy substantive trial, they settled, and the UK agreed to pay £1.1 million in damages to the Cypriots who claimed to have been tortured. It was important, I think, just to conclude that we see the Foreign Officer Minister, Sir Alan Duncan, saying that the settlement is not an admission of liability. It's not a precedent. We just feel that it's important to settle the case. And largely because of the values, those shared values between the UK and Cyprus that they wanted to promote and to continue. And of course, the desire to not go into lengthy and difficult litigation, but rather just to settle the case. They did issue they said it was a matter of regret that the transition was, preceded by 5 years of violence, loss of life, etc. But there was not a formal apology in the sense that I think Mr. Sophocleus himself had hoped for more of an apology and more of that admission of guilt. But here we saw less of that. In the end, though, it seems that they were relatively content with the settlement because while, of course, a trial didn't go forward, and they said it will be left to the judgment of historians rather than that to a judge as what actually happened and who was responsible. And there was ample evidence, which is often a problem in these types of cases dealing with historical violence. Nonetheless, they said that they were pleased to recognize this act. We are pleased that through this act, they recognize that during our anti-colonial struggle, they did use torture. So just this recognition that it did happen and that it was wrong, even though there was not necessarily that legal conclusion and that strong sense that justice was served. So maybe we see just a bit of a balance here rather than an ultimate victory of the legal measures. So thank you. That is my brief overview of the legal measures and kind of what they may have achieved and what the original expectations were. So thank you.
Thank you so much, Carollann. I think that one does not need to be an expert on political history to understand that this conflict is, of course, of high importance. It's a very sensitive issue. I'm a big fan of myself of diplomacy mediation, but sometimes
Oh, you're muted.
I'm sorry. I was saying that I'm a big fan of diplomacy mediation, but it seems that so far the outcome does not seem to be very effective. So maybe old conflicts need new methods to approach solutions. And when it comes to settlement, sometimes the problem is exactly that settlement is not a precedent, does not constitute a precedent. And this is not always something good. And the importance of apology is very important, really, in the framework of settlement and mediation. There is also a whole sector in the US, the apology law, and how we can use as a tool, I mean, the apology in settlements and in mediation processes. Thank you so much. And now I'm going to proceed with Mr. Dimitrios Kourtis. Mr. Kourtis is a PhD candidate and a research associate at the School of Law of the University of Nicosia. He's also a very dear friend and a former student of mine. I'm very pleased to be with him in this panel. And his topic is going to be It is not going to be international law and international organizations, legal obligations arising out of this, of the participation of Cyprus in the Commonwealth. Dimitrios is a master, a true master of international law, and I'm sure that his presentation is going to be of high caliber despite the short time. Dimitrios, the floor is yours.
Thank you, everyone. Allow me to share my presentation with you. I will try to be as brief and brisk and crisp as possible. I hope you are all seeing my presentation right now. Okay, so we are going to discuss a point, let's say, of controversy between international lawyers since the 1960s, or even since, let's say, the previous years of the Commonwealth, when the Commonwealth was basically some kind of British colonial association and not an association of independent nations, of course. So for the sake of brevity, I will not discuss the short history of international organizations. International organizations are secondary subjects of international law as per the orthodox positivistic doctrine of public international law. They are considered, let's say, a child of the Peace of Westphalia. They are also a child of the interwar treaties signed to celebrate peace after the end of the First World War. And finally, they are something of our own era, the proliferation of international organizations that started from the establishment of the United Nations. Allow me just to ask a rhetoric question. What is an IO? Again, the standard positivistic doctrine says that an IO, an international organization, is an entity which is generally considered a creation or a child of states. So it is set up by states on the basis of an international treaty with at least one organ that in turn has a will that is distinct from the will of the member states. This is the so-called, in French literature, volonté distincte condition. So those criteria are highly flexible. They may give rise to much oscillation between formalization and deformalization. So basically, let us now, under this lens, examine the question or the concept of the Commonwealth, the legal nature of the Commonwealth, intriguing international scholarship from the early years of the association. For instance, Professor Fawcett in 1963 described the Commonwealth as a kind of international organization, while, of course, the well-celebrated Professor James Crawford in 1979 submitted that it constitutes a kind of residual international organizations. So if we need to, let's say, adhere to the classic definition of an IO, then we might answer that the Commonwealth is not by any means an international organization. It is not, let's say, established under a binding international treaty, but more of a set of norms included in soft law instruments like political declarations and consensually adopted charters. However, the Commonwealth is an association between different sovereign states. It has a legal capacity as per the internal legislations or as per unilateral declarations or as per standard practice of all 54 of the Commonwealth associated nations, and it has several building blocks. First and foremost, it has the Crown. This is the incumbent British monarch who is considered the head of the Commonwealth. Okay, the role of the monarchy has really changed since 1926 and the Balfour Declaration. It has been reformed under the Statute of Westminster of 1931 and finally under the London Declaration of 1949, both the legal and symbolic conundrum of having a monarch, an incumbent state monarch, as a head of an international organization or international association, including states which are not, let's say, dependencies of the Crown, or more importantly, which are republican in their nature, like India or Cyprus. It has been settled. Basically, the Commonwealth has as its symbolic titular, its symbolic head, the British Crown, and this is something that has been accepted by all Commonwealth members, basically as a precondition for admission. The foundational principles included in the Singapore Declaration of 1971. So basically the Commonwealth is a voluntary association of independent and sovereign states. each responsible for its own policies. They do consult a lot and cooperate a lot in the common interests of their peoples and in the promotion of international understanding and world peace. Members of the Commonwealth come from territories in the 6 continents and the 5 oceans. They include peoples from different races, languages, religions, and display every stage of economic development, from poor developing nations to wealthy industrialized nations. This is what the Commonwealth says for itself. This is the identity of the Commonwealth as per the standard Commonwealth documents. So we see that the Commonwealth itself and the Commonwealth Secretariat, of which we're going to speak a little bit later, tries to, let's say, present the Commonwealth as an association. This is a practical or realistic application of the doctrines of international organization. It does not claim for itself the international legal personality or the international legal capacity of the full title, of the full power IO. However, it presents both the state element, that it consists of states, it includes states, and its goals, its foundational principles, something that has been described by the relevant bibliography as constitutionalization of the Commonwealth, because basically Commonwealth was a registral organization for former colonies, and nowadays is a full-fledged forum of international cooperation, both political and economic trade, and also diplomatic and, of course, cultural. Further constitutionalization of the Commonwealth edifice was effected through the so-called Lusaka Declaration of 1979 regarding racism and racial prejudice, the Goa Declaration of 1983 on international security, and of course the well-known Commonwealth Charter of 2013. Basically, the Commonwealth Charter, consensually adopted and then executed by Her Majesty the Queen and Head of the Commonwealth, was the attempt of the Commonwealth nations and the Commonwealth prime ministers, or generally heads of states and governments, to engrave constitutional or quasi-constitutional values within the fabric of the Commonwealth. Let us now turn to the organs, because the great question still persists. Do we have a volonté distinct? Do we have a different will than the will of the state parties within the framework of this organization? We have basically 2 constitutional organs for the Commonwealth: the heads of the governments, which meet a meeting. This is, let's say, the political forum. They meet every 2 years in a Commonwealth city. The meetings are attended by the prime ministers of the member country, or in the case of a republic, the president, if he's a chief executive, of course, or she is chief executive. The proceedings do not result in mere recommendations. The meetings are, let's say, dealt based on the unanimity or consensus rule. So the participants have the power to bind internationally their own states, their home states. They are heads of state and governments after all, or designated deputies. So basically consensually adopted declarations on terms of principles may have some effects in producing legally binding obligations. However, as we will discuss in the following slides, this is something that should not be overstated. The Commonwealth Secretariat was set up in 1965 under the terms of an agreed memorandum issued by the heads of government at their meeting in that year. The chief officer is the Secretary General, of course. We hosted the Secretary General during the opening ceremony yesterday, and he or she and her or his staff are the servants of the countries collectively, deriving their functions from the authority of the Commonwealth heads of government. This is something that has been, let's say, extracted from the agreed memorandum. This is not my wording. This is the reason why you see that it refers to he or his. Thankfully, nowadays we have at the head of the Commonwealth Secretariat a great woman, Baroness Scotland. So, in accordance with the 1965 memorandum, the UK Parliament passed the Commonwealth Secretariat Act of 1966, conferring on the Secretariat the legal capacity of a body corporate within the United Kingdom legal order. Many other Commonwealth countries have taken similar steps, Cyprus excluded, either by means of special legislation. For instance, this is the case with former British colonies, including Australia and New Zealand, or by making use of general legislation relating to IOs. This is probably the position that is followed in Cyprus, although we have, let's say, scarce practice since the Commonwealth has not been sued, for instance, before Cypriot courts. at least to my own research. The memorandum provided the conferment of immunities and privileges on the Secretariat and its staff under United Kingdom law, and moreover, the Secretariat is impeded from making policy choices or circulating policy papers, while it is bound to respect the sovereignty, independence, and domestic jurisdiction of the associated member states. So, the Secretary General is not by any means an independent actor who shapes the policies of the association. She encapsulates the notion of the international civil servant as constructed in the legal minds of the Invisible College of Public International Lawyers during the interwar period, and as, let's say, incorporated in the early years of the League of Nations and the United Nations regarding the office of the Secretary General. So the Secretary General in the Commonwealth framework is independent, non-political, internationally mandated, this is interstate mandated, and entrusted with custodian duties vis-à-vis the principles and primary documents governing the affairs of the Commonwealth. Moving now to, let's say, the institutionalized framework of the Commonwealth, we need to point out that there is a lot of, let's say, we have important consequences based on the consensual rule. For instance, we have, let's say, a revolving door policy regarding participation. We do not have solemn, or we do not have just solemn procedures for participating in the organization, and especially we do not have solemn procedures for terminating participations. For instance, Ireland tacitly excluded itself from the Commonwealth in 1932, while its non-participation was finalized only in 1949. Zimbabwe's membership was suspended in 2002 on grounds of human rights violations and misgovernment, and Zimbabwe's government terminated the membership unilaterally in 2003. Bangladesh, the Gambia, and Maldives were in and out from time to time, while Hong Kong lost its status in 1997 due to the transfer of sovereignty, but it still participates in several Commonwealth satellite fora like the Parliamentary Assembly, the Association of Commonwealth Universities, the ACU, or also the War Graves Commission of the Commonwealth and the Commonwealth Associations of Legal Professionals. So concluding, we might, let's say, submit that the Commonwealth is a sui generis international association founded on the principle of unanimity or consensus. It acts through formal and informal lanes, and it lacks the conflictual or adversarial nature of other organizations like the European Union or even the Organization of American States. Any member state of the Commonwealth, including Cyprus, is bound to adhere to the Commonwealth Charter, the Commonwealth Declarations, and the structure of the Commonwealth, especially the fact that the British monarch is the head of the association. Other than these foundational and reasonable obligations that stem from the quintessence of the Commonwealth as a free and voluntary grouping of independent states, formerly associated with the UK regularly as colonies or dependencies, no more legal obligations can be discerned. A general obligation of implementing what has been agreed in good faith, a corollary of the pacta sunt servanda foundational rule of international law, is of course binding upon member states, but the normative density of this obligation should not be overstated. Enforcing Commonwealth obligations and or penalizing the violation of Commonwealth principles is more of a political and diplomatic horizontal rather than a vertical or legal procedure. For instance, this happened in the case of Pakistan, South Africa, Zimbabwe, Fiji, Nigeria. Basically, the main sanction for violating Commonwealth principles is the suspension and or exclusion of a given nation from the association until the termination of the breach. The Commonwealth of Nations and the structure of the organization do not permit any kind of speculation regarding the true political nature of these procedures, and given the fact that no Commonwealth lex specialis exists, the only obligations binding the different member states are those already mentioned, stemming from general public international law, which are both minimalistic in their nature and engraved on the very fabric of the Commonwealth as a voluntary association. So thank you for your attention. I hope I was on time. That will be all.
Thank you, Dimitrios. Yes, you were on time, and despite the short period of time you had, this was a very informative presentation. Thank you so much. For all those who do not, as myself, who do not know much about the Commonwealth, this was very informative. I'm very fond of all those sui generis institutions. So now I can say that I know more. So I do not see any kind of questions available or from the audience. If you would like to make a comment or one or two sentences, each of you, and we can close this session. Katerina?
No further
Maybe
comments.
a comment on your presentation?
And in the absence of questions, no further comments. I included everything there. Thank you very much for hosting us. Thank you.
Thank you, Katerina. Carollann?
I will just echo Katerina and say thank you very much for having us. I have no additional comments, but it's been a pleasure, so thank you.
It's my pleasure too. Dimitrios?
I will follow the lead of the ladies. So
ladies.
Yes, thank you for being here.
Thank you, all of you, and many thanks to our audience too. And I hope we will meet again in a live session, and not in a distance one. Have a nice day, all of you. Thank you.
Yes, thank you.